So moving on, let's look at some substitutes for consideration. So the first substitute we'll be looking at is something called promissory estoppel. So just to give you some background about what this term is referring to, promissory is a Latin or legal term for promise, and estoppel is a legal Latin term for stop or barred. So it essentially means that in a court of law, if a claimant were to rely on the promissory estoppel theory or doctrine, then what would happen is it would stop the defendant from arguing that a promise was not made and therefore a contract is unenforceable. So you don't have to understand that in every nuance, but just know that is sort of the context of what the term promissory estoppel means. So what does it mean functionally? So promissory estoppel applies when a promise is given that the promisor should reasonably expect to induce action or forbearance by the promisee. The promise includes the action or forbearance, and injustice can be avoided only by enforcing the promise. So let's break this down. So the first element requires that a promise is given that the promisor should reasonably expect to induce action or forbearance by the promisee. So let's take a look at the first element of another reiteration of this, which is A makes a promise reasonably expected to induce reliance to B. So a promise would be, I promise that I will hire you for the year 2023. Okay? So a promise like that from a reasonable person's point of view would likely induce the subject and the recipient of that promise to then rely on that promise actually coming true. So if I told you, I'll hire you for the year 2023 as my personal accountant and I'll pay you $50,000 a year, you expecting that $50,000 for next year, you might go and put a down payment on a house. You might not go and look for additional work. And let's say that you do these things and then the promise ends up becoming not fulfilled. Then what happens in a legal basis where can you recover against me for promising you something that you then relied on and suffered a detriment? Maybe you put a down payment on the house and you can't make those loan payments because you don't have a job, right? But you only would have gone and put the down payment on the house because you expected to get paid $50,000 a year for the year 2023. So this is also called reliance theory, and it's another way for consideration to be substituted if these set of facts, right, the set of facts that apply to a specific case actually satisfy these three elements. And if they do, then for an enforceable contract, then consideration in the traditional sense of what we just went over of legal sufficiency and bargain for exchange, that doesn't matter anymore. You just can win on promissory estoppel. So let's go over the elements again. A makes a promise reasonably expected to induce reliance to B. B takes a detrimental action in reliance on A's promise, and enforcement will avoid injustice to B. So the example here then goes, John pledged $5 million to a university. In reliance on the pledge, university began construction of a new building. If John retracts the pledge, a court will most likely enforce the promise. University has acted upon John's promise and likely incurred a significant debt to its detriment. So hopefully that example illuminates what we're talking about here when we're talking about reliance theory or promissory estoppel. So the second substitute for consideration we'll be looking at is unjust enrichment. So what is unjust enrichment? Well, a court finds that a quasi-contract or a contract implied in law exists when the parties make no promises and reach no agreement, one of the parties is substantially benefited at the expense of the other, and no legal remedy is adequate. To avoid unjust enrichment of the receiving party, the party who provided the benefit is entitled to the reasonable value, not the contract price, of the services rendered or property delivered. So what this is referring to is another form of consideration that doesn't require a bargain for exchange or legally sufficient bargain for exchange. Instead, this is a quasi-contract where, because of the judicial branch and the judicial learnings through court precedent, we found that sometimes a court needs to step in and compensate somebody for the work or the value that they imparted on someone else, even when there were no promises made and no agreement was reached, simply if one of the parties was substantially benefited and there's no other legal remedy. So let's see this example. A doctor found an unconscious person on the sidewalk and provided medical treatment. To avoid unjust enrichment, the patient must pay the doctor a reasonable fee, even though the aid was unsolicited and no contract existed. So here, the doctor and the unconscious person, they didn't go into the full gamut of offer and acceptance, and then was there a bargain for exchange? Am I giving up a legal detriment? And is the unconscious person giving up a legal detriment? No, here, this was an unconscious person. They had no capacity, actually, to even enter into a contract, right? But let's say the guy or the unconscious person is sick and would have died if the doctor didn't do anything. So the doctor, out of his goodwill, provides medical treatment. So even though there was no agreement between the unconscious person and the doctor to bargain for medical treatment in exchange for, let's say, money that the unconscious person would pay the doctor, instead, the doctor just treats him. And therefore, in this case, the unconscious person received a benefit from the doctor, and the unconscious person, after he's conscious again, would probably be forced by a court to pay the doctor a reasonable fee. Right? And it's not necessarily, so sometimes there might be an underlying contract with a set amount of money, let's say $100,000, and there was a bargain for exchange. There was an offer and an acceptance, which means that there is a enforceable contract. But let's say one of the parties goes above and beyond and gives $110,000 worth of value. Maybe that $10,000 difference, a court would actually order to be paid, right, to a person. It's all if somebody benefited in a way in which there's no legal remedy. So hopefully that's easy to understand. Next, let's look at capacity. So capacity is the third element of the contract that we kept on mentioning. Remember, the elements are mutual assent, which was offer and acceptance. The second element was consideration, which is legal sufficiency and bargain for exchange. We're now on the third, which is capacity. So parties to a contract must have the legal capacity to contract. So the UCC adopts the common law in determining legal capacity to contract. So pretty much the parties to a contract must actually have capacity for that contract to be valid in a legal sense. So adults, so people over 18, businesses, these have the capacity to contract. So who doesn't have capacity to contract on default? So there's three. There's minors, which is young people under the age of 18, persons lacking mental capacity, and intoxicated persons. So what's important to note here is a minor actually could enter into a contract, and the contract could function. There's trusts, there's credit cards, where sometimes a minor is able to get like a custodial credit card or a custodial bank account, right? So a minor does not actually have a legal capacity to enter, but they probably might enter, and usually those contracts just occur as long as there's no dispute. But the rule is that if a minor entered into a contract under the age of minority, which means they were a minor at the time, later on, they can actually disaffirm their contract for lack of capacity. Thus, we call a contract that a minor enters into as a voidable contract. It's not default void, it's voidable at the option of the minor. So next we have persons lacking mental capacity. So for people that were judicially, so court, determined to be insane or otherwise incompetent before the formation of the contract, then the contract is simply void and does not, cannot be ratified and is not enforceable by law. So these are people that are insane or are deemed to be incompetent. So let's say they are a drug addict, that type of scenario. Then we look at intoxicated persons. So if mental capacity is lacking at the time of formation of the contract, then the contract is voidable later on by the intoxicated person. This situation functions much like the minor's situation, where the contract might actually be entered into, and it might continue, but later on, that intoxicated person or that child could say, oh, I disaffirmed the contract because at the time that I entered into it, I was lacking capacity. Therefore, we say the contract is voidable. So keep in mind also that you simply can't, an intoxicated person to like go through this route can't simply say, oh, I was intoxicated at the time, and then that makes it voidable, and then that person would just prove that he or she ingested alcohol at a certain time. No, the standard here is the intoxicated person's reason and judgment must be impaired to the extent that he or she did not understand the nature and consequences of his or her actions. So a person proving this in court would have to bring forth evidence that proves that him or her reason and judgment was impaired to that extent. All right, and lastly, we'll look at the fourth element, which is legality. So just keep in mind here that a promise to commit or induce the commission of a tort or a crime is void on the grounds of public policy. There cannot be agreements that, hey, if you pay me $50, I won't actually press criminal charges against you for stealing my money. Because if it were a crime or a tort, you can't promise to do it. So like not pressing criminal charges is in itself a crime, right? So this would what we would call void on the grounds of public policy. There's other instances where legality is not present. So a blatant legal violation, right? A statutory violation. Licensing statutes where there might be a law that requires a CPA to have a license to actually recover on, let's say, a malpractice suit where the CPA has to prove that he or she actually holds a license before they can even sue for a breach of contract. Then there's contracts in restraint of trade. So these are draconian, overreaching, like non-disclosure agreements or non-compete agreements, right? So just keep those in mind, that those usually fall sometimes into an unreasonable restraint of trade and would not fulfill the legality requirement to recover on a contract. So those are the four elements of a contract. Remember, it's mutual assent, then it's consideration, then it's capacity, and then it's legality. So when we look at any agreement between two entities or individuals, we look to see if those four elements are present. Lastly, what we always need to consider when we're looking at a contract or whether a valid contract was formed is something called the statute of frauds. So the statute of frauds is pretty easy. It just says that there are a group of contracts based upon their content that requires a writing and signed by the parties. So this is more about if the court will enforce a clause in a specific contract, not necessarily if a contract was formed. So an easy way to remember these five is M. Sauer, right? Mr. Sauer. And these would be a contract for marriage, a contract that guarantees the debt of another, the contracts that can't be performed in under 1 year, consumer goods over 500, and real property.